Welcome to Trial Talk, insights from experienced New York trial attorney Michael Joseph.
Hello there, this is Trial Talk with Michael Joseph. I am your host, Kevin Rosenquist, and as always, I am here with New York attorney and personal injury expert, Michael Joseph. Today, we're going to talk about construction tool injuries, the legal rights after saw, grinder, and equipment accidents. Michael, welcome back.
Thank you.
So let me give you some different scenarios here. Like let's say a construction worker is injured by a circular saw that might not have a guard on it or something like that. Can they sue in that situation like that?
Yes. So in general, New York labor laws require construction workers on all construction sites to be provided with safe tools, okay? And tools that are guarded. Now, in particular for saws, there's a specific regulation that requires all saws to be guarded. So if the saw is taken off, if the guard is taken off the saw, or even if the guard doesn't retract properly, and the worker gets cut because of that, well, they should have had a saw with a functional guard, right? So they definitely have a lawsuit under what's called Labor Law 241, subsection 6, and some of the regulations of the New York Industrial Code. Now, what we see a lot in the construction industry is that as saws get used, there's residue such as sawdust and other things that tend to build up, and they get stuck in the guard. They keep the guard from retracting. That's why it's kind of standard practice in the construction industry to take like an air gun and blow it out every day, or make sure the sawdust is kind of removed. And in some job sites, they just don't do it. So other job sites, especially you see non-union job sites, the employers will actually take the guard off the saw because the guard does slow down the work to a certain degree, and they want the work to get done faster. So when that happens, it's an inevitability, because why? It's an inevitability that someone's going to get cut. Guards kick back, saws kick back while you're using them, and if you come in contact with the blade, you're going to get cut. These things are tremendously powerful. Now let's talk about grinders. Grinders aren't saws; they don't have the same regulation for functional guards. However, what the regulations do say that is all machinery, including grinders, or equipment, including grinders, have to be kept in good condition and replaced if they have a broken part or component. So if the guard's removed, if the guard's not working on a grinder and someone gets lacerated because of that, then usually that means that the guard itself was either removed or isn't properly working, in which case the regulations require it should have been repaired. Now, it doesn't matter who provided the saw. A lot of times people ask our construction accident lawyers, my boss provided the saw. Can I sue my boss? Well, our construction accident lawyers know that in New York, you can't sue the boss because you get workers' compensation, so you can't bring a lawsuit against the boss. However, what New York law does is it provides a responsibility to make sure all workers have safe tools on the general contractor and the building site owner. So, and it's what's called a non-delegable duty. That means it doesn't matter who actually provided tools. It was the responsibility of the owner and the general contractor to make sure everybody working on the job site has safe tools. So you can sue if you're injured on a construction site because of a saw that either didn't have a guard, or the guard wasn't working properly, or with a grinder that doesn't have a guard, or the guard isn't working. You can sue the building owner and general contractor of the site where you were working.
Okay, so can you elaborate more on New York's labor law? I believe it's 241-6, and what that says about dangerous construction equipment, how it's used in the law, in court cases, stuff like that?
So what 241 sub 6 basically says is it requires all places where construction is being done to be properly guarded and have safe equipment and safe work methods. Now, it defines that responsibility in what's called the New York Industrial Code. And the New York Industrial Code has tons of regulations on everything, from safe passageways to safe ladders. This is in addition to what's commonly known as the ladder law, which is in Labor Law 240. But moving of materials, storage of materials, trenches, excavations, you name it, there's a reg on it for almost every type of construction equipment or construction operation there is. And what the regs basically do is they codify or enact into law good construction practice to make sure that scaffolds can withstand a certain amount of weight, to make sure that when loads are carried by certain equipment and transport, you have taglines so that the loads themselves don't swing laterally and hit people. The same requirements require guards on saws, and that all equipment any equipment that's in disrepair be taken out of service and repaired or replaced. There's regulations concerning electricity to make sure people don't get electrocuted. There's regulations on apparel to make sure if people are in noxious environments, they have masks. You name it, any kind of construction operation you could think of, there's almost probably a regulation to protect construction workers. Some of the other requirements, for example, are debris cases where they require that to remove debris, you have to have chutes rather than just throwing it off the third floor and hoping you don't hit somebody. So if you hit by debris and you're a construction worker, you can sue under both 240 and Labor Law 240 and 241 sub 6. Other common examples of regulations that are meant to protect construction workers on New York job sites are shoring. So, for example, if you're digging a trench, once you get below 3 feet, you have to have shoring along the sides of the trench to make sure the trench doesn't collapse back on the workers. There's a number of these regulations. So if you're involved in any kind of construction accident, you really want to speak to an experienced New York construction accident lawyer to see if your accident falls within one of the regulations that the law required a safety feature for.
Does OSHA ever get involved with these cases?
OSHA gets involved in the sense that they do enforcement of worksite conditions or worksite safety procedures. OSHA will walk around and issue fines if they see things that are unsafe. If a worker gets hurt, they'll come in, they'll do an investigation, and they'll issue fines. Unfortunately, some of the big job sites in New York have hundreds of thousands of dollars of fines, and it doesn't seem to do anything because people keep getting hurt. There have been a couple of criminal prosecutions even recently for manslaughter for rampantly unsafe conditions that result in the worker's death. However, you can't necessarily sue specifically for an OSHA. The Labor Law 241-6 is very specific to the New York Industrial Code or the NYCRR's regulations. So if you have a regulation that's a concrete regulation in the New York Industrial Code, then you can sue under Labor Law 241-6. OSHA regulations are not, while yes, they're meant to provide for worker safety also, they don't necessarily trigger the ability to sue. Although there's a lot of overlap between what the OSHA said, New York Industrial Code says.
Obviously, a lot of construction sites or a lot of contractors will use subcontractors. If the subcontractor removes a safety feature or a guard or doesn't use them so that they can go faster, as you said earlier, does the general contractor still have some liability there?
The general contractor still has all liability. Why?
All liability.
If you're employed by a subcontractor, you can't sue the subcontractor. You can't sue your boss if you get workers' compensation.
Yeah.
That's why New York law wants to make sure that somebody's responsible for worker injuries. So the general contractor is always responsible to make sure that you have safe equipment and safe work practices on the job site. So what happens is, typically what will happen is we'll sue the general contractor, then the general contractor will then third party in or bring in the employer, because even though the injured worker can't sue, under certain circumstances in New York, either contractual or if they have certain types of injuries, the contractor can then bring in the employer as a third-party defendant, and that happens a lot in construction cases. But ultimately, the ultimate responsibility for job site safety is always with the general contractor and the landowner, and it's called a non-delegable duty. Why? Because you can't delegate the duty. It's your responsibility, even if someone else does it, they do it badly, you're still responsible to make sure you have a safe site.
I'm sure these construction companies, these contractors have insurance policies for these very things. Is it a similar situation to other personal areas of personal injury where the insurance companies does everything they can to not have to pay out, and do the workers ultimately suffer for this?
Insurance companies will do anything and everything they can to avoid paying with the amounts they're due. Of course, workers suffer because the latest defense du jour is they claim every accident is staged, every accident is fraud. And
really?
Yeah, that's the newest tactic see, under a lot of these labor laws, they have no defense. They have no defense for a person who gets hurt because of an inadequate safety device. If a ladder fails, they're responsible. If a scaffold fails, the general contractor and the landowner are responsible, and in turn, their insurance company has to pay the damage. If there's another one of the various NYCRR or industrial code regulations are violated, the owner and contractor are responsible, and the insurance company has to pay. So what do? To avoid trying to pay, they're trying to come up with reasons to say the accident didn't happen or the accident was faked or this or that. But our construction accident attorneys fight these cases every single day. We go to the mats to protect construction workers, and we don't let these insurance companies get away with any of this crap.
You mentioned that you can't sue your boss but the worker can sue if they're working for the subcontractor. They can't sue their boss, but they can sue the general contractor who hired the subcontractor. Is that correct?
That's correct.
If you're collecting workers' compensation from your boss, can you still sue, or does it have to be one or the other?
No. You can always sue. So typically, this gets a little technical, but the way it works is you can't sue your boss if you get workers' compensation. But since the general contractor and project owner have non-delegable duties, you can sue them for pain and suffering. And typically what will happen in these cases is the workers' compensation will have what's called a lien, which means that out of the lawsuit or settlement, the workers' compensation carrier has to be repaid the benefits that they provided to a certain extent.
Okay. And if how do you advise workers who are injured on the job? What, assuming they're not so hurt that they can't do this, what kind of evidence do you suggest they document? How should they document? What's most important? What should they focus on? That kind of stuff.
First thing I would recommend with any construction worker who gets injured on a job site is don't just sign paperwork that the boss puts in front of you or the foreman puts in front of you. Write your own report. Describe what actually happened. Because I've seen many cases where guys are injured and foremen are trying to tell them, oh, just sign this so you can get the insurance benefits or so that the hospital will be covered. Meanwhile, they've written up a completely wrong accident version of the accident that puts the worker at fault, or that basically establishes or claims that whatever safety violation there was that caused the accident wasn't a safety violation, or there was no safety violation that caused the accident. They try attributing the accident to something else, so they can't be sued. So one, don't just sign anything. Read it before you sign it. If it's not correct, don't sign it.
But if you feel it's correct, you're okay, you're comfortable with people signing it?
Yeah, you have to do a job report. In fact, you have to do at some point a workers' compensation form too. But I would say you always want to make sure the description of the accident matches what actually happened. Don't let important details to be left out. For example, they may just say fall at work, but don't let them leave out you fell because you were 10 feet in the air and the scaffold broke. Okay? Mm-hmm. Or they may say back pain while working. Don't let them leave out you have back pain because you slipped and fell on ice. Mm-hmm. So in other words, the insurance companies and the contractors are very savvy. They try to set you up to fail from the moment you get hurt. From the moment you get hurt, the construction companies are working against you. And I think it's very important for construction workers, as they say in boxing, protect yourself at all times. Make sure that anything you sign has an accident description that matches what actually happened, that establishes that the company was at fault or that you were injured because of an unsafe condition or dangerous work practice. Make sure it's all your I's are dotted, T's are crossed. If you can, either take pictures of what caused the accident or have a coworker, or if you're a union member, have one of your union brothers take pictures of everything to document what happened so that the story can't change later.
Is there any other steps or evidence collecting or anything else that you recommend to people if they're injured with, in a situation like this?
You always want to, in any situation where a construction worker is injured on a job site, either if you're able to get pictures of what injured you, have a union member, brother, or a coworker take pictures, take good pictures, and take pictures of surrounding areas at the time you're injured. Because you know what happens a lot of times? A guy will get hurt on a crappy ladder, then all of a sudden brand new ladders will show up and be staged to take pictures. And they'll try to blame the worker for using the crappy ladder when those ladders weren't there. So I would say take pictures of, if you fall on a ladder or scaffold, take pictures of what you fell on, and not only of what you fell on and what caused your accident, but take pictures around you to show there was nothing else you could have used. That the general contractor or your boss didn't provide any other devices for you to use that were safer, because the story's always going to get turned around and try to blame you.
Do you represent a lot of construction workers in cases like this?
Our firm, me in particular, our firm has extensive experience in representing construction workers who are injured all over New York City, the Bronx, Brooklyn, Queens, Manhattan, you name it, Westchester, Rockland. We've handled almost every kind of construction accident case you can mention, and we've also gone up to the appellate courts and made and expanded the protection for construction workers at the appellate level.
A lot of times, construction workers, just people in general, that they're not going to be maybe totally clear on their rights, and they might get talked into things that they don't want to do. Are there situations where you've seen where someone like a foreman or someone like that tries to say, "Oh, don't worry, you don't need a lawyer. It's fine. We'll take care of it. You can handle this on your own." Do they try to like coerce a little bit?
All the time, every case.
Yeah, every case.
They're getting calls from the foreman or the supervisor. They're getting asked to sign a release. They're getting asked to sign documents that don't match how the accident happened. Because from the get-go, when the accident happens on a construction site, the contractors are working against the injured worker. They're taking steps to blame the injured worker. New equipment that was nowhere on site is suddenly going to magically appear, and photographs are going to get taken. Any defect, any saw that doesn't have a guard is all of a sudden going to magically have a guard. Any ice that was there is going to get cleaned up, and pictures are going to get taken. So I can't count the number of depositions we've been in where defense lawyers pull out photos and ask, "Is this where the accident happened?" And yet the client will say, or just say, "Yes, this is where the accident happened, but that letter wasn't there. The ice was where you're showing it's now cleaned, or that tagline wasn't there." So all the time, the construction workers will dummy up the site or sanitize the site to make it look like it was the worker's fault. There was nothing dangerous there that caused the accident. So you really have to protect yourself.
That's a shame, I mean, here's just people doing a job, and they'd like to be supported by their employer, but they don't get that luxury. That's sad.
As soon as a construction worker gets injured on a job, they are playing into a stack deck. The companies are working against them and working to try to defeat their ultimate lawsuit.
Yeah. Well, that's why people like you exist, right, Michael? To protect the rights.
If you get hurt in an accident, document the sites and the site conditions, and as soon as you can, call an experienced New York construction accident lawyer to protect you. You need somebody on your side, because you're playing into a stacked deck. The deck is already stacked against you, and you don't even know it. While you're supposed to be home healing, they're working to undermine your potential case.
Well, good advice. Make sure you document and hire a good lawyer. All right. Well, thanks for joining us on Trial Talk with Michael Joseph. If you've been injured in a construction site by a saw, a grinder, any other power tool, visit NewYorkTrialLawyers.org. Connect with Michael today. Share the episode, subscribe, leave a review. We appreciate it all. Michael, thanks so much for your time. Great chatting with you.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.